because he better not show up again with those kind of figures with something like this. Seriously.
Laura?
How about Timothy Leslie versus Pamela Lewis?
Good morning, Your Honor. Attorney Kyle Lowry here on behalf of Lewis. And I believe Mr. Ead is here again.
Yes, good morning, Your Honor, and Mr. Laurie. This is Attorney Mo Eid.
So, Your Honor, I think, and Mo, correct me if I'm wrong, we have an agreement on the amounts owed for the back payments and taxes on the land contract, if we can put that on the record. But we have a dispute over the amount of attorney's fees.
That is correct. That is correct, Your Honor.
Okay, so far we're good on everything then. And then, so we're down to
Attorney fees.
other than attorney fees, anything else? Nothing?
No, Your Honor. Just
Okay.
pursuant to the land contract, the plaintiff is entitled to attorney fees. Paragraph 18 of the land contract specifically says the prevailing party shall be entitled to attorney fees. And respectfully, I've discussed this matter with Mr. Laurie, and I respect his opinion. Unfortunately, that's not our client has paid Mr. Mazie significant amount of money. This matter has been, as Mr. Laurie knows from the facts and everything else that's been provided, it's been going on for since shortly after the sale of this property. Miss Leslie's been repeatedly late and repeatedly in default. And Mr. Mazie was retained in December of 2023 and has been repeatedly trying to mitigate the situation with both the plaintiff and the defendant until it just got, the amount was becoming more and more increasingly in terms of the amount that was owed. So they filed the case late last year.
Okay, so I guess, well, Mr. Lowry, let me hear from you first.
And I can email his billing that
So-
he sent me, or I can, and I'm gonna try to email it again. I don't know why it didn't go through.
So I want to clarify what the actual contract says.
Yep.
The actual contract says, in the event of an action for forfeiture or foreclosure, or for any other remedy arising out of a default under this contract, the prevailing party will be entitled to recover from the other party actual reasonable attorney's fees in the amount determined by the court.
Correct.
Not just clearly actual. And my contention with this is the reasonableness of the charge, because Mr. Ead has not placed that on the record yet, but he informed me that Mr. Mazie has charged $4,200 in attorney's fees on this case. And I don't believe that that is reasonable given my experience with land contracts and summary proceedings. I was brought into this case on the defense side of this, and our office only has 4 hours total, including all of my administrative staff getting retainers, doing the initial intake. I myself, as the attorney, only have 2.9 hours of time put into this. So I don't know how we can get to a number of $4,200. The statute for a landlord tenant case only allows a prevailing party in a trial to get $150. Now, I get that that doesn't apply to this, but I think they're very analogous to each other because they are both summary proceedings actions. So I get that he's put in all this time, but I also don't think my clients should suffer from the fact that they took a year to go back and forth when they could have filed this at any given time and mitigated those costs in a great amount. Even if he's charging, I believe they said $350 an hour, that means they have upwards of 10, 12, 13 hours into this. I was able to review the contract, prepare for this, have discussions with Mr. Ead to come to the number that was owed, and it only took me less than 3 hours of my own time. I just don't feel that $4,200 is a reasonable amount. Maybe 2 or 3 hours at $350 an hour, but $4,200 in attorney's fees on a just under $6,800 judgment. I mean, that is grossly excessive, in my opinion.
Okay, Mr. Eid, I look at the language in paragraph 18, it does say actual and reasonable attorney's fees.
That's absolutely correct.
Oh, and it's regarding a default under the contract, in the event
Right.
of forfeiture or foreclosure. So how do we get from 2023, I think it said 2023 to now? How can I possibly claim all that time period?
Well, there was a lot of phone calls, and again, he sent me, where he's billing by 0.1, which is a tenth of an hour at $3.50 an hour, which is only $35 for each either text messages or phone calls. And I guess because she was in default, this is what caused Mr. Leslie to retain Mr. Mazie. And those communications, including communications with the defendant, started in February of 2024. And then they would tell her the amount and send her the letters and phone calls with the plaintiff. And, he was trying to basically to do the right thing, recognizing that she had paid a significant amount as a down payment and trying to let her keep her home. They didn't want to just rush to the litigation. And he was, in that respect, I don't think he should be criticized. I think he should be commended. Sometimes we shouldn't just rush to file a case if we can see if we can resolve it between the parties. And Mr. Mazie was trying to do that. But I'm sure the court, from its experience, can recognize when you're trying to do that, there's a lot of phone calls and communications back and forth between one attorney and two different people. Mr. Leslie unfortunately sold this home and moved down to Florida, relying on this monthly payments to come in to help support his retirement. But nonetheless, there was, in addition to the hours spent, and I've already spent myself over almost 4 hours on this case, from the 2 Zoom hearings, not including today, and obviously preparing to review, but that's amounts billable to Mr. Mazie. But to also draft the summons and complaint, to review the land contract. There's also filing fees. It says here for the travel for the dart carrier, $299. There's
Hold on, travel. What's the travel for?
the filing fee and travel, I guess, to file the case with the court. That's what Mr. Mazie was charged for, the filing fee.
Well, those are court costs. The
Yeah.
court costs are different. I'm talking about we're just talking about attorney fees. And quite frankly, Mr. E, all this I'm hearing, it just sounds unreasonable to me that you're coming up with figures that, if I look at the language, attorney fees in the event of an action or forfeiture or foreclosure or any other remedy arising out of a default, it's got to be reasonable one way or the other. And quite frankly, if I look at just hold on.
I'm sorry, Aaron.
Just the forfeiture being filed on this matter, it nowhere near comes up to that kind of money. Absolutely, there's no way. This is summary proceeding, and there's no way it was coming up to that.
I can only tell you, based on what I was given and the information, the billable that I'm looking at, which was actually billing in terms of time spent by Mr. Mazie, is in excess of those
Or are those
numbers.
billings? Are those yours or somebody else's, I guess?
Those are Mr. Mazie, the attorney of record on this file you're on.
Oh, I see.
Yeah, not mine. I only been involved with
So,
reviewing the summons and complaint and land contract before the first
Gotcha.
hearing.
so you can't, I'm sorry, I didn't mean to cut you off, but you can't tell me then what actual work got done other than you're reading off of a ledger. That's all you're doing, correct?
That is correct, Your Honor. I just said
Right.
that it is a lot of communication between the attorney and both parties, meaning the plaintiff and the defendant, and then the drafting of the summons and reviewing the documents and the how much was billed and how much was owed, and figuring out the math, and then preparing the summons and complaint and filing it with the court, and the continued communication with the parties.
And Your Honor,
Mr.
if I
Go
may,
ahead.
I just want to say, I don't think anybody is faulting Mr. Mazie for trying to remedy the situation before it gets to a forfeiture. But I think at some point you need to know to cut your losses and just file, or else you're just trying to make as much money as possible. That would just encourage a plaintiff's attorney. I'll just continue to work out it because I know I'm going to get this giant amount at the end of the day. I've spoken to counsel in our local area that files this and is in front of this court and other courts on numerous occasions. And the two that I talk to are pretty prominent in terms of handling these cases. And one said they capped this as a flat rate of $600 for a land contract forfeiture, and the other said it's anywhere from $750 to $1,000, depending on how detailed it is. Just because he accepted an hourly rate, I mean, there's an opportunity to just continue to make money if you don't mitigate it and say, look, I'm just going to file it. So, I understand he's put time and effort into this. I just don't think that it's a case that's, from my point of view and having handled numerous cases of this type, that's something that's taking 10 or near 15 hours of work to review a land contract. I mean, I reviewed the land contract in under a half hour of reading through it. And like I said, I only have just less than 3 hours of time in the defense side of things, and we came to a resolution on what the merits are. So to need, 3, 4, almost 5 times that just seems grossly excessive.
Your Honor, final response, if I may, even if the total hours spent by Mr. Mazie are about 5 hours, which include, let's say we cap it at that, and the communication with both parties and reviewing the documents before filing, because, to make sure that the amounts claimed are correct, and to review the land contract itself and file the summons and complaint. Let's say if we cap those at 5 hours at $350 an hour, which is not unreasonable, you're looking at $1,750.
So,
And then,
Mr. Reed, when I look at all those hours you're talking about, if I look at the complaint, the material breaches say repeatedly failed to make payments in a timely manner. Furthermore, defendant is in violation of paragraph 7, failed to obtain and maintain insurance, failed to pay real estate taxes. Those are just ledger. That takes, like, even if I gave you an hour for those, that's all that takes. That's not like you're
okay,
looking at, hold on. It's not like you're going out looking at property for condition of the property, or there's some defects in something that caused it. Those are just figures. It
okay.
can't possibly take that much to negotiate something like that.
Well, it's not in terms of negotiation. The problem,
No?
again, Your Honor, is that this was probably, maybe Mr. Laurie is correct. If they would have just filed from the beginning, this wouldn't have happened. But unfortunately, they would communicate with the defendant. She would send a payment, and then, or she'd say she's sending a payment, and then the payment is not received. And then the amounts every month kept changing, and it added,
Does that
you know,
does that all take legal advice? I don't think so.
yeah, no, it may not, but unfortunately, by that time, Mr. Mazie was involved, and he was like the go-between both parties.
Okay, all right. Some of
But
that.
even if that's the case, he still had to, review the land contract and read the documents and file the documents. And
He's a slower reader. I don't see
no,
5
I'm not
hours
saying
into that.
I mean, even if it's a few hours, and then there's been now 3 hearings, Your Honor, I think at minimum, again, 1,500, 1,750 is not unreasonable after 3 hearings, with the court. And then there's the court costs, which I mentioned, which need to also be added.
We have figures on the court costs. Let's do that now. I'll make a decision on.
Thank you, Your Honor. Again,
Yeah, go ahead.
there's the personal service, which was done for the notice and the filing of and the summons and complaint, was total paid. It says $326.
Total for court costs?
No, that's just for the personal service of the notice and the summons and complaint.
How
The
do we?
filing fee and,
Hold on. Let's start with that first. $326 for process server?
that's what he was charged, Your Honor, for two separate
Do I
cases.
have some in the file? Do I have an affidavit for process serving for $326 for process
Uh,
server?
That's what he was charged with, this Dart Courier. I don't know, I've never used them before.
I guess I would look at that very closely. I'm looking for process serving affidavit here. Personal service, here it is. Got personal service.
I mean, if we need to obtain a
Doesn't
receipt
say-
from them, I can try to do that, Your Honor.
Yeah, I don't have anything. Gives me a figure. Mr. Lowry, do you have a figure for anything on that?
I
No?
don't have anything from Mr. Eid or the plaintiff for that. I have concerns that it would be $299 when most summary proceedings are served for somewhere around $25 to $30 in almost every case I've ever experienced. So I don't know how they're
Yeah,
claiming 10 times the amount of that.
yeah, I don't know why this courier service or why he uses it. Again, I'm in the outside here looking in, it does, but if that's what he,
And that's
that's what he
starting,
actually paid. I mean, I'm not making it up.
Mr. Eid, now I'm starting to question everything you're telling me because you're just guessing at why
I'm
honestly.
not guessing, Your Honor. I'm looking
No?
at, like I said, if you want me to provide a receipt, I'll ask
Do you
Mr.
have
Mason.
do you have an affidavit for it, or are you just reading off that ledger again?
I'm just going off the ledger.
Yeah, we're not, yeah, that's ridiculous for processor. You got a person in Clio he served, and this group is out of Troy, Michigan. It doesn't take $300 for a process server for that.
I don't know
No
why
way.
they're.
And I don't either, and you can't tell me either.
And Your Honor,
No.
they have every opportunity to hire a local process server. That was a choice by them to hire someone out of Troy to drive all the way to Clio.
You know, that's just maybe the services that he uses. I can't comment on that, Your Honor. And if it is excessive, the court just can make it a reasonable amount. That's obviously within the court's discretion. In the filing fee, it says, again, plus there's another $299, which he paid them to file the
what?
case.
For filing?
No, that's what they charged him to file the case. Yeah, I guess to pick up the file from.
The filing fee was $130. I'm looking at
Right.
the register of
And
action.
so they charged him an extra 160 to, I guess, pick it up from his office
There's
and
no
take it to
way.
the court.
There is no way. No way.
N-
That's the most ridiculous thing I've ever heard.
I'm not saying that, Your Honor, this is what
Mr.
he
Eid,
paid.
and you're getting in the middle of it, but that's ridiculous. I
Yeah,
got filing fee. How much was it, Mr. Lowry, without me looking? What was the
It
filing?
was $130.
that is correct.
actual
That's
filing
what's
fee.
paid to the court, but that's not what he paid. I guess that, again, this is not,
Again, this is getting ridiculous.
Yeah.
Holy smokes, man. And that gets back to the attorney fees. Holy smokes. That credibility is going out the window on this whole thing. It's ridiculous, Mr. Eid.
Your Honor,
Ridiculous.
again, maybe he spent too much time trying to mitigate this thing.
Yeah, it
and he
sounds
should have
like it.
filed.
Sounds
Yeah.
like it.
But
It sounds like he doesn't know what he's doing. He's spending way too much time on one file. That's what it sounds like.
again, he was trying to help out both parties, Your Honor. I
Yeah,
don't know.
yeah. Then maybe he needs to be a social worker and work that way because this is ridiculous. If I'm gonna make I guess I'm just gonna make some decisions. If he wants to file a motion, otherwise we'll do it that way. $700 attorney fee I'll grant. Filing fee of $130, process serving fee. I don't know where that came from. I don't know anybody that charges that much. $50 process serving fee. So we got $180 in court costs, $700 attorney fee.
Your Honor, $700, this is
All
our
right, so
third
I
hearing.
can keep going. You know what? That's what I'm ordering. You're here. You're the one that we just had a hearing on. Unfortunately, whoever you're working for isn't here. And I'm going by what that, if they want to file a motion, they can file a motion, but that's most, those figures are just ridiculous.
I'll let him know, Your Honor.
Yep, do that.
Thank you.
Because he better not show up again with those kind of figures with something like this.
All
Seriously.
right.
Thank you, Your Honor.
All right, who's doing the judgment for me? Mr. Eid, are you doing that?
Yeah, I'll do the judgment, Your Honor.
And how much? I'm okay. We'll just leave it at that. All right. Get a judgment for me.
Thank you, Your Honor.
All
How
right.
much what? I'm sorry.
No, I'm not gonna say what I was gonna say. Okay, just give me a minute here. I'm gonna write some notes.